My father was disqualified because he had the mistake of helping make Pakistan.
Like age being 25, then perhaps, to my mind, legislation could not do it through ordinary legislation. Constitutional amendment was required. But in this case, the declaration emanates from the law itself. So law is being given a certain time frame. Is pe kuch roshni dal?
My lord, it depends on the validity of the law. That's why I tried to argue that under what proceedings we are before my lordships. I rely on PLD 2012 Supreme Court 923, Baz Muhammad Kakar Federation of Pakistan. It is the case where Contempt of Court Act 2012.
आपने सारा आर्गुमेंट सुना हुआ है, proposition बता देना please.
My proposition is through ordinary law, Parliament cannot amend the Constitution.
No, fair enough.
It has not amended the Constitution.
That's what I'm trying to tell
We
you.
have added in the Constitution because how do I demonstrate
whether the court can amend the Constitution?
Court can interpret it.
Interpret in a manner to amend the Constitution or to read into the Constitution.
No, my lord.
So this is what we are asking from you, whether the interpretation can be done. देखिए इसमें एक बात आप ये आप कह रहे हैं 62(1)(f) में ये बताया गया है कि डिक्लेरेशन होना चाहिए कोर्ट से, और आपने कहा कि डिक्लेरेशन सिर्फ ट्राइब्यूनल दे सकता है. ट्राइब्यूनल अंडर सेक्शन 157 वो ग्राउंड्स बताए गए, ठीक. क्या उन ग्राउंड्स में ये बात है कि ट्राइब्यूनल इस बात पे आपको डिस्क्वालीफाई कर सकता है कि आप राइटियस नहीं हो, आप सजेस्ट नहीं हो, आप अमीन नहीं हो, आप सादिक नहीं हो? ऐसी डिक्लेरेशन आएगी तो 162(1)(f) इस्तेमाल होगा, अदरवाइज नहीं होगा.
That's what I'm saying. That in my case, FA degree was forged, BA degree was forged. Trial में
आप हमें डिक्लेरेशन कहाँ से आया आपके केस में?
Election Tribunal.
देखिए खुरम साहब, एक चीज़ है, देखिए, speaking for myself, there is no confusion in my mind that to set aside a judgment, the premises on which that judgment stands needs to be taken away. So if the judgment stands on a law, then there could be an amendment in the law, and that foundation of that judgment on which it stands is taken away, and that judgment is nullified. If the judgment stands on the Constitution, constitutional amendment is required to take care of. There's no, as far as I'm concerned, no. I'm saying in this particular case, 62(1)(f) is not a disqualification. The judgment does not stand on 62(1)(f) as such. It stands on a declaration by a court of law.
My lord.
That declaration is not done through Constitution. That declaration must be of based on some law. That law now provides a period of 5 years for such declarations. Hence, that premise, that declaration that's coming out of a law has been given a period. So wo khatam ho jati baat, 5 years then plugs that problem.
Election Tribunal has to determine on the basis of qualification, disqualification given in Election Act as well as 62-63. Why I am saying is I have also appended parliamentary debate from Senate on the amendment. It's at page 28. They have admitted it's silent. Once they have admitted it's silent, the only requirement...
What do you mean it is admitted is silent? What does this mean?
I mean, in parliamentary debate, which we can look into to see.
So why don't you look at the Constitution itself? I don't know, देखिए ये from Hebdo. Do you know what Hebdo was?
My lord.
One dictator,
my lord,
throwing out everybody,
my lord,
followed by another dictator, throwing out everybody, following by a third dictator, throwing out everybody. Are you forgetting all these things? No, please, एक second ठहरिए ना. The Constitution, original Constitution, did not have these D, E, F, G clauses.
My lord.
These are imposed by a dictator, correct or not correct?
Correct.
Why you gave it no importance? Either say we support dictatorships. Hang on, ऐसे नहीं होगा ना. We can, जरा बात तो सुन लेना. आइन का तकद्दुस उसी वक्त होगा जब हम उसका तकद्दुस मानेंगे. या हम कहते हैं हम बंदूक का तकद्दुस मानते हैं. जब पार्लियामेंट में जो 326 लोग बैठ करके कानून साजी कर रहे हैं, जो आप 326 से पहले कम होते थे, वो एक कानून साजी कर लें और उन्होंने ये किताब हमको बना के दे दी, और फिर एक शख्स टहलते हुए आते हैं, वो कहते हैं बाहर जाए कॉन्स्टिट्यूशन. मैंने एब्डो कर दिया. तमाम पाकिस्तान के सियासतदान इंक्लूडिंग My father was disqualified because he had the mistake of helping make Pakistan. But a general, you prevailed over everyone. You are not even attending the constitutional thing. You are supporting everything done by a military dictator, having precedence. Now show us this thing. Then the next dictator comes along and says, no, I introduce graduate condition. The third dictator comes along and says, no, I introduce Sadiq, Amin, right.
तो बताएं प्रोविजंस बताएं ना
कि वो नहीं है, वो भी नहीं कर सकता unless by the court of law.
He disagrees with that. He says it's गलत है.
Let me explain the formation and the power of election tribunal.
आपका आर्ग्यूमेंट ये हुआ ना कि सिर्फ प्लेनरी जुरिसडिक्शन के कोर्ट्स डिक्लेरेशन दे सकते हैं और आप कहते हैं कि अदर देन द नॉर्मल रेगुलर प्लेनरी कोर्ट्स लाइक सिविल कोर्ट्स एंड ऑल द इलेक्शन ट्राइब्यूनल आल्सो फॉल्स इन दैट कैटेगरी. This is your argument.
This is my argument. I also say that
कौन से सेक्शन में ये पावर
in constitutional jurisdiction.
Show us the please provisions of the law. Election Act में कौन से provisions है declaratory jurisdiction exercise करने की?
My lord, उसमें मैं आ रहा हूँ. Basically, election tribunal is constituted.
No, election tribunal is a different thing. आपने कहा ना election commission भी ये power exercise.
नहीं, I'm saying election tribunal.
Election tribunal की जो power है वो तो फिर civil court के power हैं उसके पास सारे.
Yes, my lord.
They can exercise the civil court powers and they can record evidence because
my lord,
before declaring any person disqualified, they must be.
Not true. The provisions
But this debate won't resolve what the problem before us is. Let us not go into the powers of the election tribunal. Here, the power it's not a question of election tribunal exercising a power or election commission exercising a power. It's a power being exercised by a constitutional court. Now, you premised your argument by saying court of law is not defined anywhere in the constitution. Can I first of all correct your premise and take you to Article 175 of the Constitution? If you read that Constitution provision, the chapter is titled The Courts. And now please read 175.1 and then 175.2. So I may be subject to correction, but there are courts of law and the courts, Supreme Court and the High Courts have other powers as well. Please read.
My lord, there shall be a Supreme Court of Pakistan, a High Court for each province and a High Court for the Islamabad Capital Territory, and such other courts as may be established by law.
By law comes here. Now read subsection 2.
No court shall have any jurisdiction save as is or may be conferred on it by the Constitution or or under any law.
Now, first of all, then the court has been defined. There are Supreme Court, there's the High Court, and any number of courts that a law may enact. Correct?
My lord.
So it is a clear distinction between the Supreme Court, the High Court, because the Supreme Court and the High Court exercise, and I presume this is the distinction, there is appellate power of the Supreme Court and the High Court where it acts like a court of law.
My lord.
And then there is an extraordinary constitutional jurisdiction of these courts,
my lord,
which it does not in the classical sense act as a court of law, but as a constitutional court. Therefore, they are called constitutional petitions. And we used to earlier write extraordinary constitutional jurisdiction. So it's an extra jurisdiction conferred by the onto the Superior Courts of Pakistan. And now we come to sub-article 2. No court shall have jurisdiction save is or may be conferred on it by the Constitution or by or under any law.